Welcome to those of you that have joined us. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join us before we start. Welcome to those of you that have joined us. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to the 5 Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join us before we start. Whilst we are waiting for everybody, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screens, and our speaker will try to come to them at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to let you know that we now have a separate section on the 5 Stone Buildings website for webinars, where you'll be able to find a copy of this recording and the slides used and any previous webinars that have taken place. And I will now hand over to Emilia.
Hello, everybody. Thank you so much for coming to today's webinar, which is going to cover the topic of guideline hourly rates. As you may know, were updated last Friday, the 1st of October, for the first time in 11 years. In this webinar, I'm going to provide you with a brief background on the guideline hourly rates and then talk you through the recommendations of the reports of the Civil Justice Council, which ultimately led to the introduction of the new guideline hourly rates. Slide, please, Joe. So what are the guideline rates? They were introduced in the late 1990s following the Wolf reforms and the implementation of the CPR. And they are, in essence, guideline figures of solicitors' hourly rates designed to assist judges to assess costs summarily at the end of a trial on the fast track or at the conclusion of any other hearing, which has lasted for less than a day. The guide to summary assessment, which was also last updated a really long time ago in 2005, says they're broad approximations. They're not intended to replace figures used by those with accurate local knowledge. So a judge who has familiarity with a particular practice area or a particular region might come to a different conclusion. They apply to both simple and complex cases, and can also be used as a starting point for detailed assessment, not just summary assessment. Before last week, as I've said, they were last updated in 2010, but extremely recently were updated by the Master of the Rolls following Civil Justice Council's recommendations. Could you go to the next slide, please, Joe? So before 2010, we had the guide to the summary assessment of costs, and the guideline every year from 2007 to 2010. They were updated by a wage index in order to account for inflation. The Master of the Rolls has been responsible for them since 2007, advised by the Advisory Committee for Civil Costs until after the Jackson report in 2009. Next slide, please. So this is what the hourly rates look like until last week. They fee earner and also geographical grades as well. So grade A, solicitors and legal executives with over 8 years experience, B, 4 years experience, C, other, or D, trainee solicitors, paralegals and other fee earners. They are also divided into 3 separate London grades and 3 separate national grades. You can see National 2 and National 3 are the same. Could you go to the next slide, please, Jo? So these are the separate London grades and separate national grades. We have National 1, the major cities and legal centres, Birmingham, Manchester, Cardiff, the South East, Cambridge or Guildford, and other wealthy areas such as Chester. National 2, other cities, including Coventry, Nottingham, Sheffield, and outer city areas. National 3, smaller cities like Leicester, Stoke, and Preston. Rural areas such as Grimsby, Blackburn, Hereford, and Shrewsbury. London was also split into 3 grades. It was split by postcode. So London 1, EC 1 to 4, which is essentially the city. London 2, W1, WC 1 to 2, and SW1. And then London 3 was else, including places like Bromley and Croydon, Dartford. Could you go to the next slide, please? What happened between 2010 and now that caused the GHR to actually stagnate for such a long period? In 2011, the Advisory Committee on Civil Costs recommended an earnings-related increase, as I've said, which is in line with previous years, but the Master of the Rolls at the time declined because he wanted more detailed evidence to support those figures. Then in October 2012, the ACCC was disbanded by the government and its functions were transferred to the Civil Justice Council, which established a costs committee, which was partly recommended by Lord Justice Jackson in his review of civil costs. There was also a new proportionality rule introduced in 2013 when assessing costs on the standard basis. And then in 2013, 2014, the CJC Costs Committee, which had just been established, chaired by Mr. Justice Fosgate, carried out a review and produced a report to the Master of the Rolls. Could you go to the next slide, please? So this was the proportionality rule regarding the assessment of costs on the standard basis. Next slide, please. Interestingly, the Fosgate report didn't take into account the new proportionality rule, but they produced some recommendations. And the approach the Fosgate committee took was to focus on what it actually costs lawyers to run their practice. So it concentrated on solicitors and adopted the expense of time approach, which required estimating the actual cost to law firms of an hour of fee earner time, taking into account the full salary costs paid to fee earners for those hours and the expenses of the firm that needed to be recovered from hours billed for the firm to break even. Then once that figure was arrived at, a percentage markup was added to represent a reasonable profit element. And they essentially got bogged down in attempting to ascertain what the actual costs of running litigation practice were, which was essentially an impossible task for a number of reasons. It was particularly criticised for the self-selection nature of the respondents because the surveys weren't randomised, and it was a very small sample of the large community of civil litigation solicitors who responded. So it wouldn't have been able to actually provide the detailed stats what it was looking for. And many law firms were actually just unwilling to provide the detail that the fosgate committee was searching for. Next slide, please. Essentially, for those reasons, in particular, a methodology which was considered flawed and the small sample size, recommendations of the fosgate committee were rejected by Lord Dyson, who was Master of the Rolls at the time, and he made a detailed statement. But in particular, he said, it's important to emphasise that to provide the judiciary and others with a simplified scheme of rates to be used in undertaking summary assessment of costs. As Lord Phillips MR explained in 2004, the guide is intended to be of help and assistance to judges, but it is not intended as a substitute for the proper exercise of their discretion, having heard argument on the issues to be decided. So ultimately, it is up to the judges. It's also important to emphasise that the guidelines were originally intended to be broad approximations of actual rates in the market. So that echoes the guide. So they're not intended to reflect actual costs of running a practice. Next slide, please. So why since then have they been languishing without an update? Well, Lord Dyson made another statement the following year in 2015, which, as they were, would remain in force for the foreseeable future, alongside proportionality and cost management. And partly there wasn't enough funding available, not enough firms were willing to participate. GHRs were, he said, becoming less and less relevant, but he did say that they weren't not relevant, partly because of advances in tech and business practices models, sub-specialization, the proportionality principle, cost budgeting, and fixed costs. It remains to be seen whether he was actually right. And so they did remain in place for the foreseeable future. Could you go to the next slide, please, Jo? But judges complained. So, for instance, in the case of Open Operations UK Limited and Invesco Fund Managers Limited in 2019 in the Technology and Construction Court, Mrs. Justice O'Farrell was required to consider the summary assessment of costs. The claimant submitted the defendant's costs were unreasonably high, particularly when compared against the published GHRs. And that's quite a common thing to do is for counsel to compare the claim costs against the GHRs. But Mrs. Justice O'Farrell said that the hourly rates are much higher, but it's unsatisfactory that the guidelines are based on rates fixed in 2010 and reviewed in 2014, as they are not helpful in determining reasonable rates in 2019. They're significantly lower than the current hourly rates in many London city solicitors, as used by both parties in this case. And updated guidelines would be very welcome. The hourly rates charged cannot be considered in isolation when assessing the reasonableness of the costs incurred. Factor that forms part of the skill, time, and effort allocated to the application, and that's still the case. Next slide, please. There were also complaints in the Court of Protection in PLK and others, which was heard by Master Whalen, who is a SCCO judge. And it was to do with the assessment of hourly rates claimed by deputies in the Court of Protection. Since 2007, the Court of Protection would generally just allow HR as claimed. And this was partly because there was a need for certainty and consistency, because the assessment of primarily by costs officers. And they had to carry out over 8,000 of these assessments every year. So the issue for determination in PLK was the method of assessment of the hourly rates. The applicant submitted that the court's current approach, which relies on the GHR, was by 2020 incorrect and unjust. And instead, the assessment should be predicated on a more flexible exercise of the discretion conferred by 44.33, whereby the GHR are utilised more as a starting point and not a starting and end point. Could you go to the next slide, please? And again, Master Whalen decried that the out-of-dateness of the guideline hourly rates. And he said, it seems clear to me that the failure to review the GHR since 2010 constitutes an omission which is not simply regrettable, but seriously problematic, where the GHR form the going rates applied on assessment. I do not merely express some empathy for deputies engaged in COP work. I recognise also the force in the submission that the failure to review the GHR since 2010 threatens the viability of work that is fundamental to the operation of the COP and the court system generally. And so what he did was essentially to come up with his own hourly rate based on evidence, which essentially applied a 20% uplift on the 2010 figures. Could you go to the next slide, please? So these are the figures that he produced. Next slide, please. There are many more complaints by judges. I won't go through all of them, but this is His Honour Judge Hodge in the Business and Property Courts, and he 5%. And he also complained about how out of date fees are. There's a table of council's fees. Next slide, please. Similarly, in the Pantaneous, His Honour Judgepelling applied an uplift of 25%. So judges were essentially coming up with their own uplifts. Now, these complaints have been anticipated, and in particular, the latter 2 or 3 judgments were handed down while the consultation was happening, or after the 2021 review had already been announced. So could you go to the next slide, please? So Terence Etherton, who's Master of the Rolls in 2020, formed a working group which was chaired by Mr. Justice Stewart, and its terms of reference were to conduct an evidence-based review of the basis and amount of the guideline hourly rates, and to make recommendations accordingly to the Deputy Head of Civil Justice and to the Civil Justice Council during 2021. They produced an interim report, which they opened up for consultation between 8th of January and 31st of March 2021. They received 103 responses to the consultation from law firms, insurers, and interest groups, law society among them, and then produced a final report which was published in 31st of July, and it didn't depart in any significant way from the recommendations that had been produced in January 2021. Next slide, please. This is just a list of everyone who's on the committee. So they had a number of specialists. Next slide, please. So the interim report for consultation was critical of the search for perfection that had been aimed at by the Fosgate Committee. In particular, they said, the history of GHRs between 2010 and the present is one where it has become apparent that the holy grail of rigorous, fully evidence-based precision sought but not achieved by the Fosgate Committee is simply not possible. Again, they echoed Lord Dyson's response to the Fosgate report in saying that GHRs are guideline rates. The intention of the rates is to provide a simplified scheme, and the guidelines are intended to be broad approximations of actual rates in the market. The approach of the present working group, therefore, has been to attempt to guide the GHR ship through the narrow strait between the Scylla of comprehensive but unachievable evidence and the Charybdis of arbitrariness. So they're basically saying they're trying to seek a balance between going into too much detail and making it up. So what they did, could you go to the next slide, please? is change the methodology. And these were their proposals that they sought consultation on. So the first was the methodology. The second were changes to the areas of London 1 and 2. They came up with new GHRs. They asked a specific question about London 1 grade D. They made some changes to the geographical areas. They also recommended changes to form N260, and they also made some revisions to the text of the guide. And this is what they were asking for comments on. So I'll talk about the methodology first. Could you go to the next slide? So rather than the fosgate expensive time approach, they decided to seek evidence on what was in fact allowed by cost judges who had experience and expertise in reflecting what is reasonable and proportionate. The evidence was to be of the rates allowed on provisional and detailed assessment. They realised that they had to do something slightly different in the business and property courts. And so they sought evidence over a snapshot period of a few weeks on the hourly rates judges awarded on summary assessment cases in the BPC. From members of the profession, they sought two pieces of information, one historical and one prospective. And they also sought summary assessment evidence as well. And information included what was actually awarded by the court or what the parties had agreed after the assessment process had been commenced. Next slide, please. So responses to that methodology were mixed. A number agreed. They thought that the perfection, again, sought by the fosgate committee was impossible. A substantial number did disagree. They were mostly claiming parties. Again, they said that the sample size was inadequate. They said the methodology included the uplift at judicial discretion, but the working group dismissed this. They said it was balanced by the fixed cost regime. They said the data on assessment doesn't take into account further reduction that may have been made by the proportionality test. They said costs were already too high, but that wasn't up to the working group. And a number said that claimed rates should be used and not rates awarded because that ignores the commercial realities of running a law firm. But the working group dismissed all of those criticisms, and the final report upheld the methodology proposed in the interim report. Next slide, please. So they also recommended changes to London 1 and 2. You'll remember that London 1 and 2 were defined by postcode. London 1 was EC 1 to 4, and London 2 was W1, WC 1 to 2, and SW1, I think. And they thought that they should redefine London 1 by nature of work by centrally based London firms rather than by geographical location, and that they'd use the BPC data as the recommended GHRs. So London 1 would primarily be for very heavy commercial and corporate work, whether that was undertaken by firms geographically located in the city or central London. London 2, all other work carried out by firms geographically located either in the City of London or the area at present covered by London 2. And the reasons for this were that it reflects the present practice, whereby very heavy commercial work attracts London 1 rates, wherever in central London the solicitors are geographically located. Conversely, it reflects the present practice for rates for other work, again, where the solicitors are in the city or in the present London 2 area. Now, there was considerable support for this change, and it was maintained in the final report. Minority did challenge it, and particularly the question arose as to what actually very heavy commercial and corporate work by central based London firms meant. The working group accepted this could be a difficulty, but they were happy with it because they'd accepted what the senior cost judge and the SECO masters had said, and they were happy to go with they found it not too difficult to define. Next slide, please. So these are the new guideline hourly rates with the old rate in brackets. You can see that London 1A for grade A has the largest increase. And it's worth noting that the guideline hourly rates are not to be retrospectively implemented. They applied from the date of approval, so last week. Next slide, please. This was the broad response to the new GHRs. In general, receiving parties argued they weren't high enough. More specialisation should be recognised as warranting separate and higher GHRs. And then the paying party said that the methodology was totally flawed, no increase was warranted, or that present GHRs were too high. And that kind of reflects how costs in general often just come down to policy issues. But the new GHRs were maintained in the final report. Next slide, please. The interim report asked specifically whether the rate of £186 for London 1 grade D was too high. This was because the senior cost judge said that the rate should be more in the region of 165 to 70, because the percentage increase was otherwise too high, and it would make it more in line with the other percentage increases. The working group was a bit concerned about this, and so they sought comments specifically on this. There was a range of responses. They were fairly evenly split, but the working group said that they didn't have a good reason for departing from the data and maintained £186. They didn't really explain why. Next slide, please. They also recommend changes to national rates. They proposed that National Band 3 should disappear and be merged into National Band 2. They were the same anyway. Nobody disagreed with that. The whole of Kent, East Sussex, West Sussex and Surrey should become Band 1 because otherwise only named cities were included. And everything else in Band 1 stays the same, and all other areas will be or remain in National Band 2. And this kind of solves the problem of the previous guideline hourly rates, that actually 44 towns and cities where fee earners were likely to be based just been omitted. So now everybody is included. Next slide, please. They also made some changes to the guide to summary assessment, and I'm not going to go through them in great detail. But one of the things they did was remove the rates for council as foreshadowed by His Honour Judge Hodge, because the working group just thought they were completely out of date and unhelpful. Next slide, please. There was also a discrete issue concerning the summary assessment form N260. The working group noted that there'd been reported a problem that firms were charging for work at central London office rates, while much or all of the work it carried out was in a regional outsourced office. So they suggested that the signatory was required to specify the location of the fee earners carrying out the work. Generally supported, it was generally supported by respondents, but there were practical issues in that it's possible for a fee earner to be nominally based in London while undertaking 1 or more days a week from home. So how is that provided for? People said that firms which have more than one location might transfer things between different offices for various reasons, and that would lead to the certification needing to span all those locations, which might be cumbersome. But generally this has been adopted. Next slide, please. So just as a summary, these are the final report recommendations. So the methodology used in the interim report was a sufficiently sound basis on which revised GHR should be based. There was also an hourly rate allowable for litigants in person increase. So I think it increased to £19 an hour. the recommended changes for London 1 and 2, so that's splitting London 1 and 2 by the nature of the work rather than by geographical location. The guideline hourly rates proposed by the interim report should be implemented in full. They kept the London 1 grade D data, got rid of National 3 and made those other updates to the national bands that I discussed. They made the updates to the revised guide and also updated the form. So that is a summary of all the recommendations. The Master of the Rolls adopted them. Could you go to the next slide, please? He approved them, he approved the new guideline hourly rates, and he's also ordered a further review within 2 years, which people seem to have been pleased about. That concludes my talk on guideline hourly rates. I probably have time to answer a couple of questions. One of the questions I've got is, are the PLK rates still relevant? Which is a quarter protection case that was dealt with in some detail in the final report, because it was raised by a number of respondents who were concerned about it. But the working group said the Master had been very clear in his judgment that his hourly rates were subject to any review of the GHR, and they held that the GHR, if they were approved, took precedence over Master Whalen's figures. I've also had another question. As the GHR is set and dependent on the location of a solicitor's practice, how might working from home impact the hourly rate permitted on assessment? Now, that's a really good question. The working group didn't really consider working from home in their report, actually. They just focused on the work done in law firms where the law firms' offices were, even though everyone were working from home. I'm not sure if this is something that judges will end up considering when they're summarily assessing costs, and particularly now people are coming back into the office a lot more. I don't know how much impact working from home is actually going to have on the hourly rate now. Sorry, that's not a very helpful answer. That's all the questions I've got. Thank you so much. If you have any more questions, please email marketing@5sblaw.com, and thank you so much for coming.